So I'm trying to get a sense of who's out there. So we got a few people, and I want to welcome you to this session on women in wills. So just a little bit about me before we jump into the talk today. So I'm an estate planning attorney. I'm in San Jose, California. I've been doing wills and trusts for families of all sorts for about 20 years. And the song that we just played is so perfect for what I want to talk about today, because it's We Are Family, right? And what I think is that estate planning women have generally been left out of this topic. Women have been left out of the process. Women have been left out of the conversation. Most lawyers, like at least the stereotype is a guy in a black suit who makes you feel bad or makes you feel stupid. And I think it's really a missed opportunity for women to get engaged with this, partly because of the family part, because I think it can be so much more than a transactional situation. It can be a relational process. It can be a chance to have really meaningful conversations about really important things, like the fact that we're all going to die and can't take anything with us. It's a chance as a result of those conversations to take some intentional actions that will make it easier for the people you care about the most when that happens, or make it easier for you to take care of the people in your life that are going through illness or death. And so I think that instead of looking at it as a chore, my invitation to everybody on this call and everybody I work with is to look at it as like this opportunity to think about really important things, to empower ourselves, to understand the documents, and to really get down to it. And I would say that most people leave longer lists and longer letters to their babysitters when they go out to dinner than they ever do in any estate plans they create, which is insane, right? We end up leaving nothing behind that's helpful to people about what we cared about, or what we hope for them. So that's my little introduction. And what I'd like to do is kind of walk you through some slides that just kind of frame the biggest issues that I think women should think about. And then we can maybe like 20 minutes, and then we can do questions. And I guess we'll do the questions through the chat. I think that would be how we could do it. So let me put my screen on for you, and we'll kind of get started. Let's see. Okay. So here we are. I think, when I was thinking about putting this together for everybody, that these are sort of the four main issues that I would say women should focus on. So one is understanding the legal framework that's in an estate plan. And then within that, thinking about money, how we manage money for the people we care about, not just minor children, but primarily minor children at first, but also older children and also our spouses. Another one is navigating marriage and divorce. And a lot of that has to do with understanding how things are owned and who owns what. And I have so many clients that come to me having avoided those conversations for a really long time. And estate planning isn't a proxy for negotiating who owns what, right? You have to do that separately, but you certainly need to do it before you can make an estate plan that will work for your family. And the last one is imagining a legacy, right? Thinking about what would you like to leave behind? What would you like people to know about you? What would you like to support going forward? What would you like to model for the next generation of people in your family? So those are, I think, four opportunities in this process. So the legal framework. Generally speaking, and I practice in California, I don't know where you're all coming from. And so some of this is going to be a little bit vague because I can't speak to every state. But generally speaking, in every state of the union, probate is a legal process that settles where a court settles an estate, and nobody gets anything until the judge says it's okay. We'll talk about that. We'll talk about each of these in a little bit more detail. Life collective magic happens is a state in which probate isn't expensive or time consuming. So the primary estate planning document in a state like that is a will. But in a state like California, where probate is both totally expensive and very slow, avoiding that is a big benefit. And so most people who actually go to the trouble of hiring an attorney do a living trust to settle their estate. And then there's taxes. There's a couple different kinds. There's estate and gift taxes. So those are the taxes that fall on giving things away, either when you're alive or after you die. And income taxes. And I'll talk about how those factor into estate planning too. So again, probate is, the way I describe it to my clients is, imagine ancient, merry old England, and the Lord died, and then everybody stole everything. And they were like, maybe this isn't, nobody's looking after the dead guy. Maybe there's a better way for us to structure the settling of an estate. So they invented probate, which is a court process where nobody gets anything until the judge decides the will's valid, everybody's been notified, the creditors have been paid, the taxes have been paid, all the assets have been identified. So there's a bunch of steps. And then in the end, the court issues an order that says, you get this, you get this, you get that. So nobody gets anything until the court says it's okay. So the benefits to that can be that conflict gets resolved in a binding way because it's a court, right? Another benefit is it's super orderly because it's a court. There's a beginning, there's a middle, there's an end, there's certain steps you have to go through. You can't skip any of the steps. And so that can be very comforting and helpful to people because it can be very chaotic otherwise. But the downside is it can be super slow and it can be super expensive, and it's also public. So everything that you file with the court can be seen by lots of people. And there are people who go through court records all the time and contact heirs and get involved and try to do things to people who are in the process of inheriting money. And so that's generally speaking why people don't like it. A trust bypasses probate. And I won't go into why in this presentation, but that's its purpose. That way, when someone dies, the court's not involved and the trust says who gets what, and the family settles it privately. And so the benefits there are it's private, it's generally faster and less expensive than a court process. But it's not perfect either. If there's conflict in a family, you're going to end up back in court because that's where the conflict is going to get resolved if it gets escalated to that point. It's also less orderly, right? There's beginning and a middle and an end, and there's the way it's supposed to happen. But sometimes families don't know that. And so they don't know what to do. There's no professional judge, supervising the process. And so sometimes it can be slow and it can be expensive. But in most families where people understand that, like, hey, when we both die, we're giving everything to our kids, for example, there's no real value to having the court involved. The family's perfectly capable of hiring an attorney, getting an accountant, going through the steps, and settling the estate. The taxes. So the good news here is I'm guessing that pretty much everybody on this call is not going to have to pay the estate tax because you have to be very wealthy at the moment. You have to have more than $11.7 million per person. And if you're married, you can double that. So, these days, $23 billion or so is when you start having to worry about the estate tax. And I mean, that's a lot of money. So this particular law ends in 2025. It was part of the Trump tax cuts. So what that just means is that the Congress in 2025 gets to pick a new number. And if they can't figure it out or they can't agree, it just resets back to what it was before the Trump tax cuts, which was $5 million per person, indexed to inflation, and you can still put it together. So somewhere like, I'm guessing $12 million or so before anybody has to worry about the estate tax, which is still a lot of money. So this is my chart. And this was the chart with the previous law where it was $5 million per person, not 10. And even so, 99.8% of the states in this country didn't owe any estate tax, or 2 out of every 1,000 estates. So I'm not thinking anybody on this call needs a lot of help with estate tax avoidance. But income tax does affect us, us being middle-class normal people, in 2 ways. So the only asset that most people will end up having to pay taxes on that they inherit are dollars that come out of retirement accounts. Okay, and so what that means is if I leave my IRA to my kids, when they take the money out, they have to pay income tax on that, just like I have to pay income tax on money that comes out of my retirement accounts. Maybe at a lower tax rate because my kids don't make as much money, right? But they're still going to have to pay taxes on those dollars. And there's a new law that says they're going to have to take it out within 10 years of inheriting it. They can't take out just a little bit over their lifetime. That was the old law. But the new law is, sorry, after 10 years, you have to take it all out because there's like trillions of dollars in these retirement plans, and the government would like to get the tax revenue. So that's one place that income tax matters. And then the other one is when you sell something that's gone up in value, you pay capital gains on the difference between what you bought it for and what you sold it for. So how this affects what happens when people die depends on what state you live in part. And so in a community property state like California, and actually most of the Western states, everything that a person owns gets revalued at death to what it was worth when that person died, so that the next people inherit it at that higher level. So like I live in Silicon Valley, and I have plenty of clients in their 80s who bought houses in the 50s for like $30,000 that are worth $3 million now. Okay, so if they sell those houses now, they have to pay capital gains taxes on the difference between $30,000 and $3 million, which is like $1 million, about a third of the gain. But if they pass that house on to their kids when they die, their kids are going to inherit it as if they bought that house for $3 million. They don't have to pay taxes on the gain. So that's also something that you have to think about when you're planning your estate. And the last thing I want to say about taxes, and I kind of missed that here, is that the way the estate tax works in this country is it's an estate tax. It's not an inheritance tax. So if your mom dies and leaves you $1 million, you get that $1 million free of tax. Okay, it's not income to you, it's a gift. If your mom was wealthy and her estate was over the limit, the current limit of 11.7, but it could be a lower limit in the future. If the estate is over the limit, then the estate pays tax before you inherit, but you inherit it free of tax. So that's something I think people maybe don't know all the time. So let me go back. So now I just wanted to talk, so that was like our first thing I think is important. The second thing is money. And I think guardianships for women can be a big issue. I don't know the ages of people on this call. So I don't know if everybody has adult kids, but if you don't have adult kids, if you have kids that are under the age of 18, then you really need to nominate guardians to take care of those kids if you die before they grow up. And for a lot of parents, I started this practice when my son was born. He's 20 now. And a lot of young parents just don't do estate planning because they just don't want to think about not being around to raise their kids. And what I always tell them is, that's not a decision that you get out of making. If you don't make it, it just means somebody else makes it. It'll be a judge, right? And so the problem with not naming guardians is my the last icon there. If nobody's nominated by a parent and both parents die and you have a minor child, like a 5-year-old kid, somebody has to be appointed as their guardian until that kid turns 18. And that's a judicial process. There's a hearing, there's a court investigation, and then there's an order. And usually somebody in the family would petition to be named guardian in the absence of a nomination by a parent. And the biggest problem there is that the judge doesn't know your mother-in-law, the judge doesn't know your brother's wife, the judge doesn't know these people, but you do. And so that's why I always want parents to name their guardians. They're in the best position to make a tough choice. Not making the choice doesn't mean the choice doesn't get made if it needs to get made. It just means you've lost all control over what choice is made. So that's why I think it's really important to do this. The other reason it's important to think about estate planning for kids is that they can't own money until they're legal adults. So in California, where I practice, you're a legal adult when you're 18. In some states, it's 21. So it varies, but there is always going to be an age of majority, at which point you are unable to make like doctor's appointments for your kids, right? You know that, or you can't stop them from getting married. You can't stop them from going into the army, right? You're no longer their custodian. And so until that time, if you left a kid $100,000, $50,000, the kid can't own that much money. Where in the state I practice, it's $5,000 is the limit. So what do we do? Well, you have to go to court and get somebody named as a guardian of that money until the kid is an adult, right? I have a case like that right now in my office where a husband died and he left half of a life insurance policy to his 2-year-old. So she can't own $300,000. So mom has to go to court to be named guardian of the estate for the baby, right? She's not automatically the guardian of the kid's money just because she's the parent. We still have to get a court order naming her that. And there's still a hearing and there's an investigation and it's taking like 6 months and it's costing a bunch of money. So, and the worst part about doing it that way is that when the kid turns 18, it's their money. There's no adult supervision after that. And if they want to buy everybody on the street motorcycles, they can do that. So most people don't go that route, but they instead, in a will or a trust, either set up a trust to hold the child's money to a certain age, like 30, 25, or at least they say put the money in a custodial account, which is like a state law trust that has simple terms and that lasts for a certain period of time. In my state, you can do it to age 25. In some states, it's sooner, but there's always some date and it's older than the age of majority. So 18 is when a kid would inherit the money in California without anything in place, but at least in a custodial account, you can keep it in trust to 25. And if you do a drafted trust, like with an attorney, it can be any age you want. It could be 40, it could be 50, it could be 30. So this is why you have to do some thinking about how you want your kids to inherit money. So this is, this is kind of like Liza's, very quick tour of issues. I'm hoping to be able to offer a monthly session and go into these and other aspects of estate planning in more detail. So I'm thinking of this as kind of the table of contents, right? Just a quick overview of issues that I think women should be aware of. So the next one is marriage and divorce. So this has to do with who owns what primarily. And I find that in my practice, a lot of people come to my office and they've never really talked to their spouses about some of these tricky issues, that is it my house? Is it our house? Is it my bank account that I inherited from my mom? Or is this something that we own together? And because I've never had the conversation prior to walking into my office, it can get pretty tense in my office. And I think it's really important to have those conversations. Again, in California where I practice, but I imagine it's similar in the states that you all live in, there are rules for what is considered marital property and what's considered separate property. And again, I have to be careful because I'm not licensed to practice law in any other state but mine. But in my state, and I imagine most states, you're perfectly allowed to change the rules as long as you do it in writing, as long as you have a conversation, as long as you're both represented by an attorney or waive your right to an attorney. You can have whatever agreement you want to have about property. Like that bank account that I got from my mother is my separate property, and I'm allowed to make gifts of it to our community to buy a house or something, but you don't own half of the money I got from my mom, right? Or in a second marriage, I'm bringing these assets to this marriage. They're mine. You don't own them, and I don't own yours. That's another kind of agreement that you can have about property. Or you can say, we're married now and everything is owned 50-50 by each of us. So there's lots of different ways that you could have an agreement about who owns what. What I'm just saying is you should talk about it, and you kind of have to talk about it in an estate planning context because it sounds so obvious when I say it, right? Which is you can't give away what's not yours, right? And so when you're creating an estate plan, you can't give away something that actually you don't own. And so in that context, it's completely important to understand what's yours, what's your partner's, and what you share. So the name for the agreement that specifies that is a prenup if you aren't married yet, a postnup if you're already married but you haven't gotten anything in writing about who owns what, or you're just subject to the default rules in your state. So again, California is a community property state. California does not care whose name is on a bank account What California cares about is where did the money come from that went into the bank account. So if the dollars in that bank account came from a what happened here? Are you guys still here? Did I fall off the call? Okay, so now I kind of need, are we back? Okay, sorry about that. Let me go back to the slideshow maybe. I'm almost done, by the way. And I'm assuming that you guys can hear me now, right? Let me know in the chat if you can't. Okay. Wait, what is the chat telling me? Sorry. Okay, I think we're good. So all I'm saying is it's important to have these conversations in the context of planning and not in the context of a divorce, but just in the context of someday we're both going to die and I don't know what I have to give and I don't know what you have. So that's my point about that. Oh no, what's going on here? Okay, almost done. So I want to leave us some time for questions. Legacies, this is my message in a bottle. This is my invitation to you to consider that a will or trust can be more than passing your checkbook off to somebody. It can be a chance to do a lot of things. It could be a chance to, for example, share your deepest values and hopes for the future in a letter that you put in the back of the plan that opened upon your death. You can use it to support organizations that have made a difference in your life by making charitable gifts in a will or a trust. You can use your will or a trust to make gifts or to remember people that have cared for you, that may need care going forward, even if you pass away. And it's a way to model things for your kids, if you have them, to show them that no matter what you have, you can always give something away. And so I think that it's an opportunity to stop avoiding the inevitable and embrace it. So that's my soapbox for you today. If you will have time, we have about 20 minutes for questions, and I'm happy to answer them. If you would like to be in touch with me, not to ask me a direct question, but if you would like to go to my website, it's my name, lizahanks.com. There's a lot of information there about estate planning. You can listen to my podcast, which you can find wherever podcasts are, like Apple Podcast. And I think in the chat box, we're going to drop in a link to the podcast as well. I've done a lot of interviews with all kinds of people that have expertise in areas that my clients could use more information about, like palliative care and advanced healthcare directives, and how to talk to parents and childhood development and all kinds of good stuff. And if you would like to get on my mailing list for future classes, then the email is lifedeathlaw@gmail.com. So with that, I'm going to stop sharing. And I guess we can do questions by chat. I think that might be the way that would work best. So send me a chat, send me a question, and I will answer it. I don't know if there's a way to see everybody. Is there? Not sure.
Not in a
Can we
Zoom.
go to gallery view? No, okay. So then I guess questions by chat would be the way to go. So ask away. Usually ask the lawyer questions is a big part of these presentations.
It looks like
Here's one.
It looks like
What's that?
we also have a question in the Q&A. So if you want to.
Oh, Q&A. Is that different than chat? Sorry.
Different than chat, but both places work. So.
Okay. So where would you recommend I look first? Just both places? I can do.
Why don't we grab the one off of the chat first from Marielle?
Hi, Marielle.
Head to the Q&A.
Okay, so here's the question for everybody. Are there community resources that can help lower income families with estate planning? Yes. First of all, you don't need a lawyer to do basic estate planning. There are, like, if you're in California, for example, but I think most states, the State Bar Association, like in our state, has a free statutory will that you can download. There's a free power of attorney. You can get advanced healthcare directives as well from the AARP. So you can do the basic estate planning, a will, power of attorney, and a healthcare directive without paying anybody any money whatsoever. There's also, like in my state, there's something called senior legal assistance. So there's often like pro bono organizations that help elderly people often put together wills. So I hope that answers that question. In the Q&A, if my uncle passed and he had no spouse, no kids, parents are deceased and no property to his name, no 401k, do we need to open the estate regardless? No, I wouldn't think so, because it doesn't sound like there are any assets to transfer. Okay, I'm hearing mixed things. Are living wills not, what? Are living will not legal documents, but healthcare proxy documents are legal and binding? Okay. i.e. doctors can override living wills, but not your healthcare proxy. Okay. So little context, this question is asking about essentially what's called an advanced healthcare directive. This is a document that does different things in different states, but it appoints somebody to make medical decisions for you if you're not able to make them for yourself. In California, that's called an advanced directive. In some states, that's called a healthcare proxy. So that's part of this question. The other thing that in California, an advanced directive does is you state your end of life wishes, like don't keep me alive by artificial means, do keep me alive by artificial means. In some states, that's called a living will, right? So I don't know where this question is coming from. So the question is, are these enforceable? And the answer is, it depends a little bit on your doctor, because a living will and a healthcare proxy or an advanced healthcare directive are legal documents that you put together with your lawyer, right? You're empowering people to act for you, and you're stating your wishes for end of life care. The problem is sometimes doctors can be aggressive, and these are not medically binding orders. In many states, including the state I practice in, there's a document called a POLST, Physician Order for Life-Sustaining Treatment, and it's always on bright pink paper, kind of like this color. That is a medically binding order on a doctor. You do that document with your doctor. And it was actually invented because of this problem where people would be in the ICU and they didn't want artificial means and the doctors were treating them aggressively. So I hope that answers your question. Okay, now I'm moving over to the chat. You're welcome, Oakland, California. Okay, I'm considering a transfer on death deed versus a living trust. Can you talk about these things? Sure. So okay, again, depends on what state you live in. Not every state has these. California has them on an experimental short-term basis, but a transfer on death deed is a kind of like, it's like a deed that allows you to name a beneficiary for your house is the best explanation I can give you. So like in your retirement accounts or a bank account, you can designate a beneficiary. When I die, I give my checking account to my son, Sam, okay? Then when I die, Sam gets the bank account, no court involved. It's just automatic because I named Sam as my beneficiary, okay? Beneficiary designations avoid probate, right? Retirement assets don't go through probate. Life insurance doesn't go through probate. Payable on death accounts don't go through probate. And in some states, transfer on death deeds do the same thing, an automatic transfer to a person, to a named person upon the death of the owner. So the idea behind them is they're cheap and easy for people who like only have a house and don't want to go to the time and expense of creating a trust to do that, right? Here's the thing. It may be appropriate for some people and it may not be appropriate for other people, because a simple beneficiary designation can't deal with the fact of, what if I leave my house to my daughter, Kate, and then she dies before I do? Well, the deed can't say, or to Kate's descendants in equal shares to be managed for them to age 30 in the following way. A living trust can do that. So it's more robust. It can account for the what if. So that's a big difference. The other difference, at least in my state, is that the law expires in 2026. So I don't think it's really a useful long-term estate planning strategy for people, because what if you do a transfer on death deed, but they're not valid in 2023 or 2033? And then, so if it's super simple and it seems kind of short-term and you're not so worried about the what ifs, it can be an appropriate thing. I hope that helps. Are we out of questions? If we're out of questions, we can stop. I'm happy to stop. Can you explain how a pour over will works within a will or a trust? i.e., if there is property in different states that isn't directly listed in a trust, but there's a pour over will, can that avoid probates in those other states? I'm having like a whiteboard moment. I would love to draw you all some pictures, but I feel like I'll just wave my hands around for now. But the idea behind a pour over will, actually, I'll use an example. This is a cup, okay? Think of this cup as the trust. This is a cup holding my biggest assets to avoid probate. Think of the will. I don't have an actual saucer here. Think of the will as the saucer underneath my cup, okay? And what the will is doing, a pour over will says, oh, if I left something out of my trust, like a little bank account over here, pour it into my trust after I die. That's the cup and saucer idea, right? Take the tea, pour it back in the cup. A pour over will is the kind of will anybody who does a living trust has. It's not very long. It only does that one thing, and it names guardians for minor kids. So it just says anything outside my trust, put it in my trust after I pass. The question though is, yeah, but like, does that work for property in other states? And the answer is no, because if things that you leave outside the trust are too big, you can't get them into the trust without a court order. That's called the small estates limit. California, that's 166,000. Other states have lower limits. And so you don't want to rely on that as an excuse not to put the things in the trust correctly the first time. And secondly, real property, because it's like physically in a place like Idaho, right? If it's not in your trust when you die and you have a house in Idaho, you're going to have a small probate in Idaho. The result of the probate, though, will be to put that into your trust in California because of the pour over will, but because it's a big asset and it's located in another state, you're not going to avoid probate there. It's kind of a long answer. If you had put your Idaho property in your trust before you died, no problem. You wouldn't go through probate. It wouldn't cost you money. It would totally work. So that's kind of a long answer, but that is the answer. Can you talk about long-term care plans? Long-term care plans. We can't afford one for both me and my spouse. So I kind of can't really address that directly because that is actually a financial decision. That's an insurance decision. That's a cost benefit decision. It's not really a legal matter, and I'm not trained, to evaluate the pros and cons of those kinds of investments. I can, though, refer you to Nolo, NOLO.com. That's a self-help legal publisher. I write books for them. They have some good publications and good information on the website about long-term care insurance. And thank you for dropping that link into the chat. And they're also part of the EOL Collective. The problem with long-term care insurance is it's expensive, and what those policies cover has diminished over time because the cost of healthcare has increased over time. And so, and depending on how old you are, it may just be prohibitively expensive to insure yourself that way. Okay, any more questions? If not, I hope that this was helpful to you.
We have two more.
And I hope Q&A, okay. Sorry. You guys are my beta testers. Okay, what do you think could be the most intimidating part of the estate planning process? I think in my experience in the last 20 years that the most deer in the headlight moment that I see people deal with is when their partner dies, often, because the person who's left behind is like sad, and they have to deal with all these legal details. It's like the worst time in your life to do paperwork. And unfortunately, depending on the kind of planning that was done, or if no planning was done, the surviving spouse or the surviving partner bears the burden of administering that. And it seems like it's just the hardest time for people. I think followed by the death of parents can be hard, but sometimes that's not as hard because often it's not unexpected, and the kids are inheriting the money. So they're, kind of motivated to get engaged with it. But I think when your partner dies is a really hard time for people. And that's actually why I'm on this mission to do better education, because I think the more we know ahead of time about what to expect and how to prepare for it, the less hard that moment should be. And I have one more thing to say about that, which is I think a lot of women of a certain age maybe none of us on this call, but I have a lot of clients of women who are in their 70s and 80s who never bothered to find out what they owned. They don't know what the assets were. Their husbands took care of everything. And women tend to live longer. And those women have they're kind of my favorite clients because they are so appreciative of the help, but they're really unprepared to deal with being financially independent. And I feel like I don't want that to happen to me or anybody on this call. I really want women to engage now so that they're not suddenly learning about how to negotiate life by themselves and finding out that, how much money their family has and where it's located and how it's invested. I don't want that to happen to anybody on this call. Okay, I am married and I have one child who's 16. I hope that your 16-year-old is a nice 16-year-old. His father is alive, but we're not married. My current husband is his stepfather, but we want to leave all property and assets of our child, or to our child maybe. Do we need a living will to state our child will get the assets if I'm not living and not my husband's siblings? Yes. So maybe in my efforts to give you a 30,000-foot overview, I skipped some important basic information, right? All states have rules about who gets what if you die without a will. Those are called intestate succession. And they may not be what you want, right? And it's just a state set of rules that if you don't write it down, who gets your money? If you want your money to go any other way, right? To a child from a first marriage, not to an ex-spouse, to your new, in any way other than the basic rules, then you should put it down in writing, at least in a basic will. Because otherwise it's not going to go the way you want it to go. And my current favorite example is Prince, who died without a will. He had given a lot of his money away to charity during his life, but because he died with nothing in place, it's all going to his family. And probably that wouldn't have been his desired result. So thank you for that question. That clarified something I should have said earlier. Okay. Wait, now there's a few things in chat. So let me go over to chat. You have been awesome. Thanks so much. Well, I thank you. I'm sure you're awesome too. I wish I could see you, but I'm glad that you found this useful. I am a hospice social worker, and the long-term care policies I've seen aren't worth it, in my opinion. Yeah, I hear that a lot from people. I don't actually have one. The other thing, because we're older and we didn't buy them when we were younger, and our financial guy says don't bother. But the other thing is, our worst nightmare is being in long-term care for a really long time. And that does happen to some people. Dementia is certainly one where people can live a long time. But a lot of people don't live that long in long-term care. So you could be overinsured for what actually happens. I've been giving art and jewelry now before I'm gone and finding the kids actually like this. Yeah, I encourage people to make gifts while they're alive, because then you can hear people say thank you. And not just physical things, but also money, pay for a grandkid's summer camp, help somebody buy a piano, pay for lessons. Like there's a lot of ways we can benefit each other. Why wait? So if you can afford it. Thank you so much for coming, and I hope I see you again in this series of courses that we hope to put together on EOL Collective. And I think I'll sign off. Take care.